That would be SJC number 12125, Commonwealth versus Douglas Garcia.
Thank you, Clerk McDonough.
Good morning. May it please the court, Catherine Stemmel appearing on behalf of the Commonwealth. The defendant in this case was convicted in Essex County Superior Court of raping his 19-year-old stepdaughter by digital penetration. At the heart of this case is an evidentiary issue. Whether the victim was properly permitted to testify as to a statement made to her by her mother that conveyed a marital communication between her mother and the defendant. The Commonwealth's position is that the victim's testimony was properly admitted under a plain reading of the governing statute.
Let's ask you a factual question first.
Yes.
Was the statement first testified to by the mother?
The statement about what the defendant had told her,
Yes.
it was first asked of the mother when the prosecutor called her on rebuttal. The mother denied that she had told the victim anything about this statement.
And would you agree, just taking that one, that that would not be admissible?
I agree that under the statute, under a plain reading of the statute, it would not be admissible. I think there's case law stating that given a lack of objection, such testimony might come in, but under a plain reading of the statute, I think that what should have happened in the case was that we should have been permitted just to call the victim. And we should have been permitted to call the victim for the reason that the prosecutor described, which was that this statement to her mother was part of the dialogue that prompted the victim to make the statement that the defendant had elicited
About being maybe pregnant?
about being maybe pregnant.
Are you suggesting it might be under the doctrine of completeness?
I think it might be under the doctrine of completeness. It might be simply to rehabilitate the victim. I mean, in circumstances where the defendant has elicited testimony of the victim in an attempt to impeach her, the Commonwealth can rehabilitate the victim by explaining why this happened. And I think maybe
And why would that be true, though? We're talking not about a privilege, as you know. We're talking about a private communication. That's a disqualification. And the whole theory is to protect statements made during the marriage. If this statement comes out, then the purpose of the statute, the private communications privilege, the spousal disqualification, is damaged.
I think that's true. I mean, there's no way to say that it doesn't impinge upon that interest. And I think that this court and the appellate courts in Massachusetts have said a couple of things. One is that the courts have held that statutory privileges such as these are to be strictly construed.
Not a privilege.
Privilege. And in this case, in this particular case, I think in that context, I think the difference between a privilege and a disqualification is a distinction without a difference.
What are the,
Just in this,
what other disqualifications are there?
I'm not sure what other disqualifications. I mean,
how do we know
there
it's
are other. There, I
Doesn't
do not
law
think that
treat
it's
them
different.
as basically the same in other contexts?
I think, yes, I think that is true. And I think that obviously from the perspective of how it's applied, whether it can be waived or not, they are different. But I don't think it makes a difference in this case. And I think what the court has held, and I would point the court in particular to in Gray, I can never say it, in Ray grand jury subpoena, where this court construed the spousal privilege to strictly to hold that it doesn't apply to grand jury proceedings, even though obviously the purpose of the marital privilege would be applicable there.
What's the difference between the marital privilege and the spousal disqualification?
The way I think of it, and I confuse them myself, the spousal privilege is the way I think of it, means that the testifying spouse, the witness spouse, can elect not to testify if he or she chooses. The marital disqualification says that neither husband nor wife shall testify as to the conversation of the other, and that's, I'm sorry, the marital communications disqualification. It specifically references the husband and wife's testimony as to private conversations with the other.
is it case law, or maybe I'm just misremembering, that if there were no objection, it's not as though it throws out the whole proceeding if it comes in, if there's no objection, is that right?
If there's, yes, and I think Sylvia,
Would
and
be
I'm not
admissible.
sure
It would
that
be-
I'm not sure that I cited it for this proposition, but Sylvia is cited in our brief for the suggestion that absent an objection, that it may be considered.
But you agree, even though this came in rebuttal, that the previous objection preserved the issue, don't you?
I think the problem, the problem with the defendant's objection in this case is that he stated, you know, for the record, I object. The judge went on to explain, and the defendant said, right. To the extent, obviously, it's a determination by this court. I don't think, the appeals court found that it wasn't preserved, that he, in essence, had acquiesced in the judge's reasoning. Certainly, he made an objection, and that's a question for the court.
Can we step back? This is a very strange context in which this comes in. So the defendant, so the wife testifies, and it's not hearsay if the wife testifies, but it's within the realm of disqualification, and she says she has no memory of that statement being made.
Correct.
So there's no evidence that he had admitted to the sexual act through the wife.
Correct.
So then you bring in the alleged victim, and the alleged victim says what the wife had told her, which is hearsay, correct?
Correct.
Not admissible for its truth,
Correct.
but argued for its truth.
I thought it was for impeachment.
I don't, it was not argued for its truth. Well, two things, and this is a thicket of a case, I will admit.
But let me step
But-
back. I mean, there was no instruction. The judge said you may consider it only as to the credibility of the mother.
That's correct.
So, but the credibility of the mother was at issue only to the extent that she had denied what was otherwise inadmissible because it was within the scope of the disqualification.
Correct.
So you're telling the jury that the only thing you may consider it for is whether or not you believe the mother as to her denial of a statement that should not have even been asked.
And hence the thicket.
And then, and the judge does not give any instruction to the jury to say you may not consider it for its truth. The judge only tells the jury you may consider it only in evaluating the credibility of the mother.
Well, I think that implicit in the statement, you may only consider it for evaluating the credibility, is that you may not consider it for its truth. I do not think that the way it came in was correct. I think that the concept was correct, and I would suggest to the court,
The concept being that if the mother, you mean the basic point that if the mother has this conversation with the daughter and says, this is what the defendant said, you're saying the daughter could testify to that if there weren't a hearsay problem.
correct. And
So even if, despite the disqualification, this is incompetent testimony, even if there's no objection, it might be allowed to come in, but even if both sides don't want it in or do want it in, it doesn't matter. The disqualification exists. Say it only comes in for doctrine completeness or rehabilitation, whatever you want to call it. And let's say that Judge Welch's instruction is only admitting it not for its truth, but for the state of mind of the mother, meaning credibility.
the state of mind of the mother?
Yeah.
Okay.
Well, let's just say that that's what the limiting instruction meant. Why isn't this unduly prejudicial? Now, all of a sudden in this case, in rebuttal, we're going to hear a statement of the defendant where he's admitting to the sexual conduct. So, assuming all those arguments are correct, why isn't the probative value substantially outweighed by the danger of undue prejudice, and perhaps even only undue if Creighton applies in this situation?
But when it's in the form of a question, that's it?
Are you talking about the
answer.
victim's testimony?
Right, right.
A couple of things with regard to that. I'm sorry, I completely lost my train of thought.
Well, the jury's hearing about the statement of the defendant.
The issue is whether it was unfairly
and
prejudicial
whether
to
it's
come in.
unfairly
Correct.
prejudicial.
Well, first of all, I think that in comparable circumstances, the court acknowledges that the jury's presumed to follow instructions of the court. And this has occurred in very prejudicial circumstances. And I think the cases I cite in my brief are prior bad acts, where prior bad acts are introduced due to things elicited by the defense. And the courts have held in that circumstance that juries will follow the correct limiting instructions. In this case, I think it's pertinent that the jury is hearing it from the victim herself. I think we all agree this was a credibility contest between the victim and the defendant. To the extent that the victim is bolstering her own credibility, it's different from if a third party was bolstering it. It was different than, frankly, if the mother was stating it. So as to the prejudicial effect, it depends on the same finding of credibility regarding the victim in this case. So while obviously it could be prejudicial, obviously it is prejudicial, the Commonwealth's interest was also high because we were depending solely on the credibility of the victim. We were asking the jury to believe the victim. And when the defendant attacked her credibility by eliciting this statement, we are entitled to rehabilitate her. And obviously, in any case, you're going to weigh the probative versus prejudicial. But in this case, first of all, the defendant never argued that point below, I don't think. In fact, I don't think that that's the way it was argued by the defendant on appeal either, but as a strict statutory question. So in the circumstances of this case, I don't think that it was unduly prejudicial.
I mean, I take your point that the credibility of the alleged victim matters a great deal, but the judge's instruction didn't say you may consider it as to her credibility. You said it may be considered only as to the credibility of the mother, whose credibility did not matter.
I agree, but it didn't. In essence, if you look at from a prejudice standpoint, it's as though no evidence about the statement came in, because the mother denied it happened, and the victim's testimony was limited to impeaching the mother. And I don't think any of that was correct. I think that the judge should have allowed the victim to testify for the reasons that the Commonwealth argued.
Because you say that once she's the one testifying, it's not covered by the disqualification.
Correct.
But then it's hearsay.
Correct. And
But then it's hearsay,
it is hearsay, but it was
not
in this.
admissible for its truth.
Right, for the victim's state of mind to explain the context of the statement that the defendant had elicited.
I mean, but I guess Judge Lowy's, the point that I think Judge Lowy's making, or the question he's asking, the one I'll ask again is, I mean, can a jury hear a statement from a defendant which essentially said, I admit I did it, when that's the issue at trial, and say, oh, you should not consider that, you should consider that only as to the credibility of a woman whose credibility doesn't matter?
And
What's a jury supposed to do with that?
The only point I would make, which is not an empty point, I think, Your Honor, is that they didn't hear it from the defendant. They didn't even hear it from the mother. They heard it from the victim.
I mean, quite apart from that, do you not think that there's an issue in this case about I think that the appeals court is absolutely right, the erroneous instruction or explanation to the wife that she did not have to testify?
I think that I don't think that the colloquy happened correctly. Two things with regard to that. I mean, first is the case law is very clear that in general, a defendant doesn't have standing to object to his spouse's colloquy.
But in this case, it seems, at least I am inferring, that if she knew that, even though it was the defendant who called her, I get that, but she may well not have testified.
I don't think, I understand that the clues that the court is thinking about when they say that, but I would note a couple of things. First, the defendant did suggest at the beginning that the mother might not testify. He said something kind of confusing, defense counsel, but he suggested she wouldn't testify. And I would suggest that the defense might not have called her if the victim had said what they wanted her to say, if she had acknowledged the pregnancy statement. But the fact that they then needed her, I don't think the court should deduce from that the mother didn't want to testify. Second, when the judge asked her the only question he asked her, which was why the colloquy was frankly not sufficient, was about about testifying about marital communications. I'm sorry, do I have the quote here?
Yeah, but she didn't have to testify at all.
That's correct, but to the extent she indicated that she would assert her privilege, it was just with regard to the conversations, not with regard to testifying at all. And I think it is evident in this case that the mother had only things helpful to the defendant to say. And the defense, if they wanted to establish otherwise, if they wanted to establish that she wouldn't have testified if she had been properly advised, then they could have filed a motion for new trial to establish that. And they didn't do that. And I think in the standing issue is true even when the spouse is adverse. But in this case, I think it's almost disingenuous for the defense to challenge her waiver.
Well, how about as a general matter? Let's say that you have a insufficient colloquy with somebody who has a spousal privilege, or there's a confusion between the privilege and the disqualification and the colloquy. Is that something where the defendant cannot object to the spouse testifying? Is that an issue that's preserved that can be beneficial to the defendant on appeal?
I'm sorry, I didn't follow the question.
Can the defendant raise the issue of the insufficiency of the spousal privilege qualification?
No, I think that the case law is clear that he can't, that he lacks standing. And the one exception that the appeals court relied upon is a case that's been described in other cases as exceptional. It was a case where there was a question about fundamental fairness, the Commonwealth versus Rosa, because in that case, a wife had been held overnight without bail before she was brought in to testify, and the court found in that case that she had just been unfairly treated and railroaded in a sense, and that frankly bears no resemblance to what happened here.
One last question. You said, in closing, the ADA said, quote, he thought it was his wife, close quote. How is that not arguing it for its truth?
I think that obviously if you just took that sentence, but if you take it in the context of the paragraph, I mean, the prosecutor was clearly arguing arguing it from the perspective of the victim and the credibility of the mother, and in its entirety, despite the slight change in phrasing, I can't believe that jurors would have suddenly thought that this was a different ballgame based on that one sentence. That the prosecutor's argument was ringed with phrases like, whether this has the ring of truth, and the entirety of the argument was clearly targeted towards the credibility issue that it was proper for.
All right, thank you.
Thank you.
Ms. Mencken, good morning.
Good morning. May it please the court, Michelle Mencken on behalf of the appellant Douglas Garcia. I think that the court is tuned in to the fact that we really don't have to reach the statutory privilege question here because the evidence was erroneously admitted for myriad other reasons. And in fact, probably...
When you mean you're focusing on the disqualification, right?
Yes.
So
Okay.
suppose we want to reach it. Can you ask me what's the effect of the disclosure to a third party on the disqualification?
Well, to be sure, the language of the statute only talks about testimony, so it only disqualifies the spouse from testifying to the contents of the communications. But the purpose of the statute really can only be effectuated if you think about it as a disqualification of the communications themselves. So what's the purpose of having a statute that prevents a spouse from testifying to these things as opposed to prevents admission of these things? That would target behavior by the spouse, sort of a betrayal in the taking of the stand and disclosing of these things. But if that were sort of the harm to be combated, then why not disqualify the spouse from taking the stand at all? The wife may betray the husband and take the stand and testify against him. She has the right to do so. And the legislature has said, but if you do so, you can't go there. You can't talk about these private communications because those are inviolate. And the
Why should they be inviolate, you know, as opposed to attorney-client? I mean, you know, what, if you start from the proposition that the every man's evidence is the presumption of what's supposed to be available, and the disqualification as written in the statute says neither husband nor wife can testify about private conversations. Once you go outside of that framework, why should we expand that so that a third person is to whom one of those spouses described the conversation?
Well, first, let me say that the expansion doesn't go very far in terms of enhancing the truth-seeking function, because what you're admitting is really unreliable evidence that is probably objectionable on a number of grounds. If
But
you're talking about,
suppose it was a confession.
well, then you have the additional problem of it being incredibly prejudicial, and I agree with Justice Lowy's line of questioning about how can this come in and not throw the case against the defendant in any form, and I think that the appeals court was right to focus on that. But if you're, with the exception of the circumstance that you'll see in some cases where say in a divorce case, a defendant tape records a private communication with the wife and then seeks to play that in court. With the exception of that, when you're talking about the evidence coming in a different form, you're talking about a totem pole hearsay, basically. So it's problematic and it's not that reliable.
can
So
I
it doesn't really enhance the truth-seeking
Can I ask
function.
you a question about the history of the statute? When was this statute enacted, and is there any legislative history?
I believe that it was 1875, and I have to check my notes, and there's really no legislative
No
history.
legislative history. Is there any rationale that has to do with the conception of marriage that was in effect in the late 1800s about it not being something that should be, I mean, if marriage was then looked upon as really just one entity, I'm just wondering whether that played into this notion that, you know, and really it would be like testifying against yourself.
I believe that historically that was an issue, but I think that the statute has been revisited and not amended since then, and sort of in the development of the case law, that framework has become antiquated, but the need for this protection has survived even under the new conception of marriage.
And how does this statute relate to the spousal privilege? When was the spousal privilege?
I think they were enacted together.
Together.
This is all one piece of legislation.
Okay.
There is an amendment to the statute pending. It's passed in the House and it's gone on to the Senate Rules Committee, which doesn't relate to the spousal privilege, but it relates to a parent-child privilege. And it's interesting to look at, and I think trying to get back to what Justice Botsford was asking about, why protect this? Why protect this any differently than, say, an attorney-client privilege or the clergy privilege? And I want to note that it's difficult to sort of line up the marital privilege next to the statutory privileges that come after it in Chapter 233 because they're all so different in terms of who can assert the privilege, whether they're self-activating or not, what disclosures are permitted or prohibited, and in what contexts. They're all over the place, so we can't sort of line them up and try to get uniformity. But there's an important distinction between all of those sort of client professional privileges and the marital privilege and the child-parent privilege, which is that in the professional context, there are also ethical constraints that prevent the professional, for ethical reasons and perhaps on fear of sanction from an oversight body, from disclosing confidences.
But that wouldn't apply to a third person, right?
Sometimes yes and sometimes no. I mean, it depends how the third person came about the material.
Well,
So,
assume it's because it was disclosed by one of the spouses.
well, our position is that if it's disclosed by one of the spouses, it's still disqualified because it's the communications themselves that are privileged. But if you look at an attorney who has disclosed something in bad faith, I think that the case law is that that is not competent evidence against the person, that the person has a right to prevent the use of that information against them.
Ms. Macon, isn't the point of the third party not impacting it that the whole point is to protect private communications between spouses? That there is sanctity in those communications during the marriage. And if one of those spouses says something to somebody else and it comes out, that's not fair to the other spouse as it relates to the purpose of the disqualification.
I completely agree with that, and really, if you look at the federal system, it's a privilege, not a disqualification in the federal system, but it has roots that are as ancient as our disqualifications roots, and what they do is, and what the parent-child privilege does is, they make it that both parties have to consent. You can't disclose without the other one's permission. What the effect of that is, it should be that means that material is not competent evidence against the defendant if his wife has gone and disclosed it without his permission. And again, it's not, the wife has no duty, unlike an attorney or a psychotherapist or a priest, to keep those things confident. So the only way to really create this sanctuary that the legislature was clearly trying to do, the only way to do that is to actually focus on the communications themselves.
But the legislation itself reads, neither husband nor wife shall testify as to private conversations with the other. And I think you agreed that that speaks only of testimony by one against the other and not the testimony of a third party.
I agree, and I think that the reason that this hasn't really come up is where I started with it. It's just, it may have been hard for the legislature to foresee that, we would be talking about this hearsay coming. It's already not supposed to come in. It's just, that's the rules of evidence. If something is disclosed to somebody else, that person's not allowed to come in and say, oh, she told me that he said that blah, blah, blah.
But I guess my question to you is, are you saying that we should interpret the statute to encompass a bar against private communications even when they don't come in through the testimony of the husband or the wife? Or are you saying that we should devise a common law rule which would go beyond what the statute provides?
I'm saying, I would urge the court to interpret the statute as encompassing as protecting the communications themselves. I think that if you look at the language in the cases that we've cited, this has been the sort of instinctual way that this statute has been interpreted over the years, and it's the way that commentators.
So no matter whether it falls into a hearsay exception.
Yeah, no, get back to the hearsay stuff, because I think that's the reason it won't come in, right? It's all hearsay.
Ordinarily, it won't come in because it's hearsay. And in this circumstance, even if, and I strongly dispute my sister's position that this could have come in for the complainant's state of mind, but in this situation, even if it could come in, it was just too prejudicial to come in for that purpose. And really, it was such a tangential point. This was completely collateral, so it had very, very minimal, if any, probative value. Unlike, so here you have the complaining witness who initially lied, it should be noted, and said that she never claimed to be pregnant. And it wasn't until she got recalled and fixed up by the prosecutor that she said, well, I said it, but it's because, and she gave her explanation. Part of that explanation was that the complainant's comment about claiming to be pregnant immediately followed the mother's reportedly saying, well, you're not going to be able to prove this case. There's no physical proof. So there's a sort of a logical connection there. And if the complainant was going to be allowed to be rehabilitated in this way, then something with a direct link like that arguably is more appropriate. But this, as context for that, is so it's so tangential that it couldn't possibly be permitted, even if it weren't so prejudicial, which it is.
The hearsay issue is not going to solve the statutory interpretation question that Chief Justice Gans just asked, because the person testifying to the private communication may be testifying in a manner that the statement is an admission by a party opponent. So for instance, it could have
True.
been the criminal defendant. So the fact that it's hearsay is not going to solve the statutory interpretation question.
Well, the reason that I brought it up, and I'll get back to what you just said, but the reason that I brought it up is that would explain why the legislature didn't take the time to draft out that eventuality, because it's already built into the rules of evidence.
But here's for instance, the psychotherapist privilege, I think I'm correct about this. The privilege, what is privileged is the communication, right? You can't have testimony about the communication.
That's correct. I think, though, just to be accurate, I think that with the psychotherapist patient privilege, there's a case of this court called Brandwine, which actually says this really only, it only applies when there's a sort of a criminal proceeding going on.
Okay, but doesn't the statute use the word communication?
Yes.
So you've got that's focusing on the I'm trying to get to your point of really, even though they said in terms of husband or wife shall not testify, really what they were after was the conversation. I'm just suggesting that statute suggests if they wanted to do that, they knew how to do that.
Well, and again, we point in our brief that those other statutory privileges, including the psychotherapist patient privilege, were written way longer, more recently than the marital privilege. And I don't think that it's fair to just assume that the legislature didn't revise the marital disqualification because they meant to keep it that way, when it could just as easily be inferred that the legislature was satisfied that the courts were interpreting or speaking of this statute as if the communications themselves were disqualified. Anyway, so there wasn't the need to go back and revise it. And it's not as if it's been revised and they deliberately didn't change that language. It just hasn't been revisited. But you made a point about that this could sometimes be the admission of the party opponent, and I just want to remind the court that this actually would be still totem pole. So let's say that you have a police officer who wants to testify to the state of police knowledge at a certain point in the investigation and wants to say, well, the wife told me that the husband told him that the murder weapon was under the bed. Well, that's still a problem, and this court has actually faced this in the case Walker that's cited in our briefs. It's still a problem because you've got the hearsay of the wife's report to the officer.
I guess one concern, let's imagine you have a husband beating his wife, making statements during the course of the beating. Wife then, police come, wife reports what the husband said while he was beating her. That testimony can't come in?
No, it can't. And, the wife is going to make excited utterances in that context, describing the actual act of the assault, and that is the offense. And so, what relevance would those communications have? And you also, Your Honor, depending on the factual circumstances, there's a question of whether this is the kind of conversation or communication that is covered by the statute versus, a verbal act or a threat. I mean, this just isn't that case.
So is there case law that says in Chief Justice Gantz's example that because of the circumstances in which that conversation is taking place, it's not covered?
Well,
Outside of the scope of the statute?
I think that there are cases that talk about written communications. I don't know of any case that's that scenario, but I do know that there are cases talking about written communications where the court has said that this is not a conversation that is covered by the statute.
I'm sorry, isn't there something in the statute that exempts when there are crimes against the spouse?
That's
Statements
That's the
made.
privilege.
I believe that that's the privilege. I would have to review the statute quickly.
But it's certainly not a conversation.
It's not a conversation. So if there are no
Okay, thank
further
you.
questions, thank you.
Thank you, Leander.